Bismillahirrahmanirrahim. Alhamdulillah. Salatu wassalamu ala Rasulillah. Let us start our class today with a recitation of Al-Fatiha. So, before we start the class, I would like to remind all of you that, as usual, please register your attendance in the attached Google form in the column relating to law of contract. And I really hope that by today, we can finish the topic law of contract, and after Raya, we can start a new topic about Islamic contract, law is contract in Islamic transaction. Okay. So, Bismillahirrahmanirrahim. Sorry. Kejap. Kejap ya. Okay. Okay. Okay, Bismillahirrahmanirrahim. If I'm not mistaken, we've done the topic about coercion, and today we're going to proceed with a uh, new vitiating factor that will affect or negate the free will of a person in a contract. We've seen so far that one of the requirement under Contract Act under Section 11, that a valid contract, the one that is enforceable and binding under the law, must have been entered into by the both party willingly, out of their free consent. So in the presence of this factor, the one that we call vitiating factor, uh, the the consent given by the party is not um, freely given, rather it was tainted by these elements. And now we move to the second vitiating factor, that is undue influence. Undue influence, normally when I want to explain about undue influence, I will always draw my attention to the case of Ayah Pin. The case of Ayah Pin. I think for Malaysian student, they know about Ayah Pin is actually uh, a spiritual leader, teaching and preaching the what do we call deviated teaching of Islam. They claim something which is sorry. So it is a group of deviated teaching, which is very famous around 20 years ago. What I want to explain here is that if you read back about the case of Ayah Pain, you may find that the follower of Ayah Pain were really obsessed with Ayah Pain, even though he is a deviated the teaching brought by Ayah Pain is deviated from the religion of Islam, but the follower of Ayah Pain were really obsessed with him and totally believe and surrender whatever they have to Ayah Pain. So let's say, presuming that one of the follower of Ayah Pain already surrendered and uh, transfer the title of their house to Ayah Pain for the purpose of in economically sacrificing for the furtherance of the preaching of Ayah Pain. The followers, credited a lot of money, transfer a lot of money, give a lot of property, and later on they found that they were cheated, and the teaching of Ayah Pain is a deviation from the true religion of Islam. So for sure, at the time they give their property, give their money to Ayah Pain, it looks like they have been giving what they give to Ayah Pain to the cause of Ayah Pain's teaching. It looks like they are actually giving consent, but their consent can be said not to be freely given, in the sense that their mind, there was elements of undue influence exerted by Ayah Pain to the teaching that negate the free will of the follower. So, in this regard, we can say that those who were unduly influenced by the person having dominance over them, that has that can dominate the will of the follower, there are strong possibility that the case for undue influence can be established, and we can try to prove that the consent was not truly or freely given. Okay, so the section that govern undue influence is section 16. Okay, whereby it states that a contract is said to be induced by undue influence. First, you have to establish the existence of relationship between the parties in the contract, like Ayah Pain and his follower, whereby Ayah Pain, you must prove that Ayah Pain has been dominating the will of the follower. Okay, you need to bring an evidence to the court to the effect that this follower was truly into the teaching, and because he was so obsessed with the teaching of Ayah Pain, he was willing to sacrifice and give everything he has to the group, the Ayah Pain's group. Okay, so that is the first thing that you have to prove. Secondly, you need to prove that the person uh, the dominating person, the person sitting in the dominating position, the dominant party, like Ayah Pain, uses his position, okay, to get unfair advantage over the other party. So it is not enough for you just to establish that there was a relationship of dominance between the parties in the contract. You also need to prove that the dominant party, okay, like Ayah Pain, the spiritual leader, need to exert his influence, need to use his domination to the effect that uh, it will cause unfair advantage to the other party. For example, Ayah Pain has been advising or ordering the follower to transfer property to the name of Ayah Pain for the purpose of furthering their teaching, so on and so forth. So there must be some sort of evidence to prove the uh, to prove the fact that to prove the allegation that the dominant party has uses the position. Okay. So so what is the effect of undue influence? For the undue influence, the effect will be the same, that just like in coercion, if you can prove this element, these two elements, the effect will be that the contract entered into um, is considered voidable and under the law, and I've explained to you what does voidable means. Okay, so this is the illustration, illustration for undue influence. You can look at this illustration after this. Okay. For your information now, I'm using this slide. This slide. This is already uh, uploaded in Google Classroom. This slide. This slide. Okay. So the case to illustrate this matter is Molly and Lonan, whereby in this case, just like Ayah Pin, the fact is similar to the case Ayah Pin, whereby the defendant used his religious influence to the follower, and out of the what do we call it? Obsessed to the teaching, the plaintiff transferred gift amounting to 140 to the defendant. And later on, he want to change his mind, and the plaintiff brought Morley here brought the case to the court to um, claim back the money, the value of the gift, okay, that he gave to the defendant. And the court held that the elements of undue influence has been established, whereby the defendant here uses his religious influence to dominate the will of the plaintiff, and the influence caused the plaintiff to transfer certain amount of property amounting to up one to 140k. And since this case in this case the elements of undue influence has been established, and the court held that the contract was voidable, and the plaintiff, the affected person here, the plaintiff has the choice. He has the option either to reject, to cancel the contract by forcing the defendant to return back whatever amount of money or gift he submitted to the defendant, or he can also choose to continue with the contract and approve whatever he gave to the defendant. Okay. So next we move to another vitiating factor. After undue influence, we have the third vitiating factor, which also affect and undermine the free will of the party. Okay. So when we discuss fraud, I always draw your attention to the difference between fraud and misrepresentation. They are closely related, but now let us look into fraud. When we discuss about fraud, you need to always uh, remind yourself about the difference between fraud and misrepresentation. So the governing section for fraud is section 17, whereby it defines fraud uh, to mean acts done with intention to deceive or induce the other party to enter into the contract. Okay, the most important part is here. You did any act, okay, with an intention to deceive. So this fact distinguishes or set apart fraud from the misrepresentation, in the sense that in fraud the person making it, okay, had the intention to deceive. Okay. Whereas in the case of misrepresentation that we will see later, it is not necessarily that the person making misrepresentation will have the intention to deceive. Maybe he misrepresented, but the misrepresentation is due to his ignorance or due to his lack of knowledge, due to uh, his negligence, so on and so forth. But for fraud, you actively and consciously have the intention to deceive the other party in the contract. Okay. So it even though you deceive the person, okay, you have the intention. For example, you supply information about a property that you are going to sell, okay, but it is a must for the other party to whom the fraud was made to rely on your statement. For example, you supply uh, a fraudulent statement, okay, with intention to deceive. But the other party carried out due diligence or uh, went to ask for another third party and he did not fall to your fraud. So in this case, there's no element of fraud. So you must establish first you made some statement, okay, with an intention to deceive, and that statement or that information supplied to the other party must be relied upon by the other party in the contract, or else without the presence of these two elements, then there is no case for fraud. Okay, just like in here undue influence, if you can see, it is not enough that you establish that the person has a dominant person, but you also need to prove that he uses his dominant position to get unfair advantage from the other party. So the case the principle is similar in the sense that you need to prove that there's some sort of unfair advantage suffered by one party, the affected party, which normally will become the plaintiff, um, uh, out of their reliance because they rely on the statement made by the defendant. Okay. So similarly, just like the effect, the other vitiating factor for fraud, the effect is that it will cause the contract to become voidable. Okay. So you can look into this example. Here, Ah Jing and Rose. Ah Jing already knew diamond was fake. So if you look into this example, at the time, Ah Jing here provided or supplied the information relating to the diamond for the sale of this diamond, he already knew of the fact that this diamond is not the original one, but instead he cheated Rose. He made fraudulent statement by stating that the diamond, the fake diamond to be the original diamond. Okay, but he knew the fact, the 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 real fact about the real quality and the real fact of the matter. So in this illustration, Ah Jing had the intention to deceive or cheat Rose. So here, this representation made to Ah Jing can be called as fraud, can be regarded as a fraud, provided that Rose rely on the representation or statement made by Ah Jing. Okay, so let us look into the case to illustrate this matter. Uh, Case Lechemi and Anamalai. Anamalai told plaintiff to sign the loan. Okay. Anamalai here was actually a legal counsel, a lawyer acting on behalf of the Lechemi. Okay, and Lechemi was she could not read. So she was an illiterate person. So he told Lechemi, Anamile told Lechemi and asked her to sign a document which was claimed to be a loan document, but actually it was a sale agreement, and because the plaintiff signed the document, uh, it is actually a declaration from from the plaintiff to sell the land to the defendant. And when this matter later on, Lechemi discovered about the fraud, and she brought the matter to the court, and the court ruled in favor of Lechemi, and decided that there was a fraud committed by Anamile. Why? Because there was a clear intention to cheat on part of the defendant by what do we call it? Uh, 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 by telling, knowing that the plaintiff is illiterate person, and he cheated plaintiff by providing false information regarding to the nature of the document and all of this. And due to the statement or representation, Lechemi had relied on the information supplied and just follow whatever instruction given by the lawyer, and then eventually he signed the document which she thought to be just a loan document, but it was actually a sale agreement. So there was a fraud. So here the contract was voidable. So next, we continue with misrepresentation, another vitiating factor. Okay. Uh, what is misrepresentation? Misrepresentation means a false statement made by one party, okay, which induces the other party to enter into a contract. So if you look into this vitiating factor, most of the vitiating factor, if you analyze all of it, at the end of the day, you will realize that all these vitiating factor is are used or asserted by the wrongdoer, okay, by the wrongdoer to ensure that the other party to the contract agreed to proceed with the contract. Okay, so like for example, misrepresentation, the misrepresentation is used to ensure that the other party will be attracted and enticed to enter with the to enter to sign the contract. Okay, so the difference, as I said earlier, the difference between fraud and misrep, uh, for misrepresentation did not contain the element, the intention to cheat, in the sense that yes, you know that you did not supply the correct information, so you have misled the person. Okay, but you had no intention to cheat, which distinguish misrepresentation from the fraud, where because fraud the person making it had the intention to cheat. Okay, so the case to, yeah, okay. So, let us look into the illustration. It is actually the same illustration which I've showed you just now about this, but the difference is that under this example and illustration, Ah Jing really believed that the diamond was an original diamond. It's not a fake one. He really believed that. He had the belief that the diamond was original, but he did not know, out of his ignorance, out of his lack of knowledge, lack of expertise to verify the to do the verification. Okay, so when Ajing made representation about the nature of the diamond to Rose, he did not have intention to cheat. Why? Because he really believed that, he thought that the diamond was original and genuine. So uh, if you look into the previous slide here, the illustration for fraud, Ajing here knew from the very beginning that the diamond was a fake one, but he told the buyer, told Rose that the diamond is a genuine or original diamond. So I hope by looking into this illustration, you may get the real picture, the real nature of both misrepresentation and fraud, and how these two elements um, share some sort of similarity, but it is there's a clear demarcation between the two with regard to intention to cheat. Okay. So the case to illustrate about fraud is you can refer to case of Pig and Gurney. In this case, Mr. Pig here sued promoter of a company, purchase price of a company after relying on false statement in the prospectus. So if you are not familiar with this word, when a public company they want to offer their shares, okay, if they want to issue public offering, want to offer their share, the company's share to the public. So the invitation for the public to buy the share must be coupled with a document that is called prospectus, in which all the relevant information relating to the company together with the project or investment that will be the company is going to embark to, all the investment that the company will do in future, what will be the project that the company will invest in, all those matter will be stipulated in the prospectus. And the main objective of supplying prospectus to the prospective shareholder, those who still considering whether to buy the shares of the company or not, is that they can rely and refer to the information contained in the prospectus to make rational judgment, to make decision, to make calculation, okay, about the viability of their investment, whether it is viable, whether the investment in by buying the shares in the company would become a good investment to them. So all those information in the prospectus will help or accommodate the buyer, the future shareholder of the company to buy the share. So from this, looking to the importance of prospectus, because it will be used and relied upon by the person, those who want to buy the shares in the company. So for sure, the information in the prospectus, all the details, all the information stipulated under the prospectus must be correct, or else people must be um, um, would be misled. People would be misguided because they rely upon information that is not correct. So, like in the case of Pig and Gurney, it happened that there was negligence on part of the officer of the company, and due to the negligence, there was some false information. In I would say inaccurate information supplied in the prospectus, and as a result of the inaccurate information in the prospectus, many prospective shareholder, prospective investor rely upon the inaccurate information, and later on they suffer loss due to the incorrect calculation. So the affected parties in this contract brought a claim against the company for the supply of inaccurate information. And in this case, the supply of inaccurate information was not regarded as fraud. Why? Because the company did not have intention to cheat. Rather, the inaccuracy originated from the negligence on part of the officer. So that is why this case falls under misrepresentation rather than fraud. Okay. So, okay, let us go to the last vitiating factor, which is a mistake. Uh, Before we proceed further, I would like to clarify here is that all the um, all the vitiating factor will result in voidability of the contract. In other words, if you have elements of coercion, you prove undue influence, fraud, and misrep, all those vitiating factor will cause the contract to become voidable. That is one thing. However, we need to treat mistake quite differently from others in the sense that if you prove the elements of mistake, the one that is recognized under the law, okay, mistake of fact, so the effect is that the contract will be void. Okay. It's not voidable, but for mistake of fact, the one that is recognized under the law under section 21, the effect is that it will render or cause the contract to become void. Okay. So mistake is ignorant of fact. Okay, you are unaware about the essence of thing, i.e., subject matter of the agreement. You had a mistaken belief about the nature of the subject matter, nature of the things related to the contract. Okay, but it must relate to the fact, not to the law. So mistake of law is not recognized as a defense. So let's say if you had mistakenly believed about a state of legal provision, then it will not serve as a defense to you because law only recognize mistake of fact and not mistake of law. Okay. Ada lagi orang nak masuk. Sekejap, So, there's two type of mistake. Bilateral mistake, whereby both parties in the contract had made mistake. So the effect, the contract will be void. Similarly, if one of the party make mistake, then the contract will be valid. Unilateral mistake. We will look into this matter again. Okay, let us look into bilateral mistake. So this is the illustration. In this illustration, you can see that this person here owns a ship and he want to sell his ship to a sailor. Okay, however, Mat ship was lost and drowned in Selat Melaka. Okay, however, at the time when Mat and seller were making the contract, both parties did not know that the ship has lost and straight in the Selat Melaka. So the mistake affected or touched on the subject matter of the contract, and both party at the time they entered into the contract had no knowledge about the subject matter, i.e. they really thought and believed that the subject matter was still there, but okay, so both of them had mistake of fact about the existence of the subject matter. So this is as an example for a mutual mistake, and this thing will cause the contract to become void. What about unilateral mistake? Okay, so you can look into this illustration. The car seller here uh, um, already explained to the customer that the car is sold without airbag. is already explained and clearly clarified to the customer. However, the customer, the buyer here, mistakenly believe that the car comes with an airbag. So here, there's no element of misrepresentation because there's no concealment of fact. Nicole here, as a car seller, already supplied the information. What should be made known to the buyer has been supplied. However, the on part of uh, the customer mistakenly believed that the car had some features like airbag, but uh, the airbag, the car does not come with airbag. Okay, so here only one party makes mistake and it will not invalidate the contract. The mistake comes or originate from the misguided belief of one of the party. So in this contract, this contract is still valid. Okay. Okay. So for discharge of contract, let me see. Okay, remedy. Okay, let us look into discharge of contract. What does it mean, discharge of contract? Discharge of contract means a termination of a contract. In other words, how could we put an end to a contract? Or in what circumstances, in what way a contract can be discharged, can be put to an end? Okay. So first, by performance. So you can discharge, you can terminate a contract by I don't think the word terminate here is a good or proper word to uh, illustrate the matter, because discharge mean you, like when you discharge a contract by performance, you are actually fulfilling and carrying out all the obligation that you should do under the contract. So for example, when I sell my car to Ali for 10,000 K, so when I uh, surrender the car to Ali and Ali paid me 10,000 K, the contract has been discharged by both of us, by me and Ali, by the fact, due to the fact that I have performed what is required under the agreement. I have surrendered the car and he already paid me. So this contract can be said to have been discharged by way of performance, because both party has done or perform their obligation under the contract. Okay, so the relevant section is section 38. Parties to the contract must perform their promise as per according. This is according to the contract, and the performance must be exact and precise. So when both parties uh, perform perform or do whatever thing that is required from them under the contract, we can say that the contract has been discharged by way of performance. Okay. Okay. Secondly, a contract can also be discharged by way of consent. Okay, what does it mean? If you want to discharge the contract, you can go and ask permission from the other party. Tell them that you are going to terminate this contract, and if the other party to the contract agree to uh, your demand, they also want to terminate, then this contract can be considered to have been discharged um, by way of consent. Okay. So according to section 63, if both parties to the contract agree to end the contract, okay, and to make new one, then the original contract need not be performed as it has come to an end, provided that both parties to the contract, okay, must agree. Okay, they must agree and provide their consent or indicate to that effect. Sometimes they don't verbally say so. They may show their intention to that effect through their conduct, so on and so forth. And as long as you can get their consent, both of the parties provided their consent, then we can say that the contract has been discharged. When a contract has been discharged, the effect is that you are no longer required under the law to perform what is required by law, what is required from you under the contract. So you are free. You are not legally bound to perform under the contract anymore. Why? Because the contract has been discharged. Okay. Next, contract discharge by breach. What does it mean? Under Section 40, when one party has refused to perform or disable himself from performing his promise, the other party may put an end to a contract. What does it mean? For example, I sell my car, I promise or I offer Ali to sell my car, and Ali accepted my offer. Okay, so now there's a contract between me and Ali. So under the law, I am legally bound to surrender my car, and Ali is under obligation to pay me the purchase price, okay, 10k. But when I surrender my car, Ali refused to pay or surrender the purchase price. In this situation, the refusal of Ali's refusal to pay the purchase price uh, amounted to a breach to the contract, because he did something um, contrary to what is required under the law. He did not do or perform what is required under the law, under the contract. So in this contract, I can apa put an end to this contract. Why? Because of the breach on Ali's part, because Ali had breached this contract. So the effect is that I can consider this contract to be discharged due to the breach on part of Ali. Okay, so one of the party in the contract does not perform or fulfill his promise. So when I say for example, I request Ali, I'm willing to submit or surrender my car, but he refused to pay. So now the problem comes from his part, and the breach originates from his part. What I can do, I can discharge myself from this contract, and I don't have to submit my car to him. Why? Because he already breached the contract, and that breach, okay, serve as a valid ground under Section 40 to discharge the contract. So that after that, I will be no longer required to perform my obligation to submit the car under the contract to Ali. Okay. Okay, this one requires a little detailed explanation. Um, Discharge by frustration under Section 57. If I'm not mistaken, this topic came out in the previous final exam question. Okay. Um, okay, let us look into this matter. A contract is frustrated when there is a change of circumstances making it impossible for the parties to perform the contract. Therefore, the discharge by consider frustration is also known as impossibility of performance. What does it mean? Due to certain change that's taken place, okay, the change render or cause the contract to become impossible to be performed. Okay. For example, I always give this example to my student. For example, Hard Rock Cafe plan to organize a rock concert at their premise. Okay. For example, they call and invited Sweet Charity to perform at Hard Rock Cafe, and they already sell uh, tickets to the fans. Okay, and the fan fully book the ticket. All ticket uh, uh, has been sold. Okay, so later on, one day before the scheduled concert, uh, the members of Sweet Charity got into accident, and they are not able to perform on the decided date. So what happened here, the fan who already bought the ticket cannot just simply sue Hard Rock Cafe for failing to bring the band to perform at the promised date. Uh, what happened here, there's some change in the circumstances that take place before the date, i.e. the accident, which caused the band to be unfit to perform. Okay, so this is a simple illustration, simple example to show about the impossibility of performance. It's not that Hard Rock Cafe doesn't want to perform their obligation by bringing the band to perform at the promised date, but they are they are not able to do so due to the occurrence of some event which render the performance of the contract to become impossible. Okay, so in this case, what happened is that under the law, the hotel, the organizer, Hard Rock Cafe, need to return back the money they collected, the proceed of the sale of the ticket. They need to return back the money to the fan who bought the ticket, um, because under the law, the effect of the uh, 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 impossibility of performance is that it will cause the contract to become void. Okay. Okay. Okay, you can later on look into this illustration. Okay, so the last topic, let us go to the last part of law of contract, which is remedies for breach. Just now I have explained a little bit about breach of contract to you. Breach of contract when occurs or happen when one of the party fail to perform their obligation under the contract, okay, or they falls short of what is required from them in the contract. For example, under the contract you have to pay 10k but you can only pay 8k. It's not that he did not perform, he partially performed, but he did not fully perform his promise. So breach can come in various way, but generally it is it comes into being when you did not uh, honor your promise in the way that is required from you under the contract. Okay, so when a breach happen, the affected person, what are available to the affected person? Remedies here means things that court can give to the affected person. For example, I give a 10k loan to Ali, and he promised me to pay the loan in 1 month. After the agreed period, the expiry of the agreed period, he failed to pay. For sure, now he breached his promise, and the remedies available to me are what if I go to the court and if I win the case against the person, against the debtor, against Abu, then what can the judge order Abu to do to remedy my situation, to remedy my problem? So that is what remedies mean. So remedies are thing or orders that court can make in order to remedy, to cure the problem faced by plaintiff. If it's related to debt, then he can order the defendant to pay the debt. If it's related to subject matter, he can order the subject matter to be moved, to be re-surrendered, to be surrendered to the other party. Kejap Okay. Sikit lagi. Okay. So there are four main remedies. First one, damages. So you need to be really careful. There's a difference between damage and damages. Damage is the loss suffered by the person. Okay, damage is the loss. When we add s at the end of the word, it means the monetary or pecuniary amount of money that sought by the plaintiff. Okay, let's say you suffer 1 million loss. That is your damage. So when you go to court, you want to apply for remedy. One of a remedy that court can give to you is to give you damages, to award you damages. Damages here is referring to the money that is payable by the defendant to the plaintiff. So damages, when it has s, it's about the amount of compensation, okay, that plaintiff claim and payable by the defendant. Okay. Okay. I think this is the type of damages: nominal damages, substantial, general. You can read on your own this one. Okay. Quantum merit is actually also order to pay amount of money, amount of money that is payable by one of a party to the contract to the other party for in cases whereby the party in the contract did not expressly state the amount that is payable under the contract. For example, you ask the person to build you a house and you don't clearly stipulate the exact amount to be paid to the contractor. So let's say he has done 50% of his work and you ask him to stop the work. So for sure, you don't know the real value of to pay for the work that he has done. So here, when he goes to the court and make a claim against you, asking you to pay for his work, so the one of the remedies available to the contractor against you is that he can claim quantum merit, and the court will make assessment, will value the how much is payable to the contractor according to the work that he has done. Okay. So what is the difference between quantum merit and damages? When we say damages, you have quantified amount of money. Okay, you claim 1 million, you have exact money. And under quantum merit, you don't have the exact claim, the exact amount. Why? Because it is not stipulated under contract, or there's partial performance on other by other party. Okay. So what about specific performance? Specific performance is actually an order by the court ordering the party to the contract to perform certain obligation. What's the difference between damages? Sometimes, if the one of the party breach the contract, you can it's easier for you to just ask the court to award you damages. You get the money. Your loss is cured through money. But sometimes, if the subject matter concerns something that is very rare and it is not easily accessible, for example, for example, you're buying a vintage car, for example, or you're buying a piece of land, and the other party breach the contract, then you can you sue the person, but you don't want money, you want the subject matter. Why? Because we presume that a land, even though it is in the vicinity area, it will never has a similar value. So if you want the subject matter and not the money, you can ask from court specific performance, in the sense that the court can order the owner of the land to transfer the land to you. For example, in the original contract, the owner of the land promised to sell you the land for a certain price, and later on, the owner of the land, uh, what do we call it, breach his promise, um, and refuse to transfer the land to you for whatever reason. So in this case, you don't want damages in terms of money, but you want specific performance, and the court, if it's found that it is fit to do so, it is reasonable to do so, the court can order specific performance, i.e. the court can issue specific performance and force the seller to honor his promise under the contract. Okay. Last one is injunction. Injunction is an order by the court to prohibit, threaten, or the continuing illegal conduct of certain kind. What does it mean? Injunction is actually an order by the court to specific person to stop from doing something. For example, in my case just now, I want to buy a car from buy a land, let's say land, from Ali, and Ali later on breached the promise, breached the agreement, and he tried to sell. He was in negotiation to sell the land to another person. So, knowing that he is still in the middle of dealing with a third party, I can, in the course of the trial, because if we were to wait until the trial end, it may take some time. What I can do is that I can ask from court injunction to stop Ali to sell the car to third party, pending determination or pending the decision of my dispute against Ali. So the court can make various type of injunction. It is whatever order the court thinks fit and suitable in the situation to give justice to the party. Then the court may order injunction. Okay. So that is all for the law of contract. I think that's all for today. Thank you very much for your time, and don't forget to fill up the Google, this one, attendance. Okay, the attendance, Google form attendance. I think this one. Okay, so we will have a full physical class after Raya. Thank you very much. Any question before we end this class? 56%. Any question? If there is no question, that's all for today. Thank you very much. Selamat Hari Raya and Assalamualaikum warahmatullahi ta'ala wabarakatuh. Okay.
Waalaikumsalam. Thank you.
Waalaikumsalam.
Thank
Selamat
you.
Hari Raya.
Thank
Thank
you,
you,
sir.
sir. Raya.
Thank you, sir.